Both sides will have 15 minutes to present their arguments, and appellant, you may reserve up to 5 minutes if you so choose. I understand again that this is not a criminal case, but I like to say this only because that way I don't forget. I remember to do it whenever it is relevant. We don't mention victims' names, and we don't mention the names of minors. We use initials or just refer to them as a victim or a minor. So, and when you're not arguing, if you would mute yourself so that there wouldn't be the background noise and so forth. Appreciate it. Okay, you may proceed, and just let me know if you want to save some time for rebuttal.
Thank you, Your Honor. Good morning. I would request 5 minutes for rebuttal.
Thank you.
Good morning, Your Honors. May it please the court. My name is Attorney Connie Hightower, and I represent the appellant SUMSS Property Management in this case. I will provide a brief statement of facts with the court. I know that this case has been before this Court of Appeals before, although before a previous panel, but I do want to make sure that we address some of the pertinent legal arguments. But the facts that I believe that are pertinent to this appeal is that the parties in this case are specific. Plaintiffs are Marsha Santomauro and Lisa Madden, and the defendant is SUMSS Property Management. That's it. Although there seems to be some other people or some other players, those are the only parties that are at issue in this case. And those are the only parties that any court orders would pertain towards. There was a purported settlement agreement in this case on December 6, 2017. That purported settlement agreement is problematic for numerous reasons. Almost immediately after December 6th of 2017, SUMSS requested to return the case to active docket and to invalidate the purported agreement. The parties then briefed the issues in January, and the defendant followed up with a supplemental brief supporting its position of invalidating the settlement agreement and returning it to active docket, and that was filed in March of 2018. On March 13th of 2018, Judge Kimbler, who was presiding over the case at the time, held a hearing on the terms of the agreement and whether or not the agreement should be invalidated, and that hearing was held based on SUMSS motions. As a result of that hearing on March 28th of 2018, Judge Kimbler issued a decision, and he determined the essential terms of the agreement. And that decision is very important in this case, as he eliminated certain areas which were out of the court's jurisdiction. Namely, those would be the matters that are under the sole and exclusive jurisdiction of the probate court, as well as matters which concerned non-parties. Those were included as problematic areas in SUMSS briefs, and Judge Kimbler removed those. On April 18th of 2018, Judge Kimbler issued a final and appealable order which formally eliminated those provisions, but there were other provisions which were added which were not in the agreement. This was appealed to this Court of Appeals, and the final appealable order was reversed, in part, and terms were eliminated from the final. The case was reversed in part, and the final appealable order was reversed, and the terms were eliminated from the final. As terms were eliminated from the final entry and terms were added. So that was specifically, in short, why this Court of Appeals reversed that. On October 23rd, 2019, this court issued a decision that stated, as well as providing instructions to the trial court about the removed terms, which were not addressed on April 18th in the final appealable order. Court of Appeals rebanded it and said, and I'm quoting, "We caution, however, that our directive should not be construed as to limit the trial court's ability to consider any previously unresolved issues stemming from the terms disputed in this assignment of error." And that was in the court's decision on page 56 and 57. The problem is, and one of the problems that essentially is causing us issue in this case, is once those removed provisions that were removed after a hearing by Judge Kimbler are re-added into this purported agreement, the court is adopting an entirely new agreement that needs to be looked at in the totality of that new agreement, not what was included in the April 18th order, but what is now in the current trial court judge, Judge McLaughlin's February 26, 2021 order. Now that they are incorporated, they are ripe for appeal. We have raised 6 assignments of error in this case, but the crux and the main issues of this appeal are that in totality, the total purported agreement contains items and persons over which the court lacks jurisdiction. The February 26, 2021 order added items which were eliminated by a prior judge without the new judge holding any hearing or referring to the previously eliminated terms and findings of fact by the previous judge. On April 26, 2021, the order added additional terms that were not purported in the purported agreement, which was one of the reasons why this court reversed the April 18, 2018 order in the first place. Trial court judge did not hold a hearing or conduct an independent investigation. Statute of frauds applies to real properties. This is the first time that anybody can bring an issue as to statute of frauds is at the appellate court because the trial court magistrate did not hold the case. So only times any issues that would be brought before any issues to be brought before this court would occur as a result of the trial court's judge's actions would be at the Court of Appeals. And then in short form, much of this violates the due process. And I submit to this court that the reason why this is a problematic agreement is that it is a square peg, and continuously this square peg is being attempted to be placed in a round hole of which it cannot be placed. Exclusive jurisdiction is clear, and Ohio Supreme Court has been very clear as to the exclusive and sole jurisdiction of another court, that a court that does not have jurisdiction cannot issue orders in regards to that, even if those orders are a part of a purported settlement agreement.
Counsel, let me just stop you here, because you have a lot of issues in your brief, and you've thrown out a lot of issues this morning. I want to make sure I understand. Are you still contesting the fact that that this was not an agreement, that there was no meeting of the minds? Because that seems to be an issue about what we ruled.
I am, Your Honor, and I am because now the totality of the agreement is different. When the appeal occurred in April or May of 2018, it was an appeal from the final appealable order, which was in place at that time. That order eliminated terms that were not incorporated in that final and appealable order. Now that those terms have been incorporated, that changes the whole flavor of what would be the agreement based on this new judge's findings. And so, yes, I am arguing that as well. And I also disagree with what seems to be the appellee's contention that once an appeal has been filed and that final appealable order was reversed in 2018, that bars the appellant from bringing up any further issues. But as we do have a new final appealable order, and those issues were not addressed previously. So yes.
Okay, but I guess I want to make sure I understand. If you're contesting that there's no meeting of the mind based on this new order from, the revised order from the new judge, or if you're saying you don't believe that the Court of Appeals actually decided that this was an enforceable settlement agreement and that that there was a meeting of the minds. Do you see the thing I'm saying? To see the difference, because you keep responding to me under the new terms and the totality of the circumstances. So I think what you're saying now is you definitely are contesting that there was a meeting of the minds and that there was an enforceable agreement. You say now based on the fact that there are new terms added, and you look at the totality of the circumstances. But I'm getting at, I guess, also, are you contesting the fact that the Court of Appeals found that this was an enforceable agreement?
I am contesting that, and I guess I don't want to retract too much and say, based on the new terms, but I guess when the appeal was filed in 2018, the appeal was filed for the issues that were ripe at that time. And some of those issues as to certain terms in the purported agreement were not necessarily before the Court of Appeals at that time. What was before that court was based upon the April 18th order issued by Judge Kimbler. And so if in fact the Court of Appeals ruling as to there being an enforceable agreement applies to this case, then I believe that that's missing key facts when it's taken part and parcel with this entire order. I hope that makes sense, because I believe that the appellant has the right, now that there's a new order that refers and includes terms from December 6th of 2017, that they can address whether or not those terms are enforceable. It wasn't required to be addressed solely in the last appeal. I hope that answer makes sense.
Thank you.
Okay, and I think I might have a couple minutes.
You still have 2 minutes before your rebuttal time. Mhm.
Okay, thank you. Specifically, what I do want to point to is that exclusive jurisdiction. I think regardless of what any party would agree to, that the exclusive jurisdiction over probate matters deals with, goes to the probate court. When we look at this order from February 26 specifically orders the co-executor and the executor to transfer land. That is specifically and exclusively and solely under the jurisdiction of the probate court. It's an attempt, even though the judge was incorporating what was in the transcripts, it still is attempting to make that round peg fit in that square hole, as well as unrepresented parties, from co-executors, which are not parties, to individuals who are not parties. There's no personal jurisdiction. And as to the not holding a hearing, I believe that some deference has to be given to what Judge Kimbler determined after he held the hearing on March 13th, and that Judge McLaughlin did not hold a hearing. And I'm apologizing for using the judge's names. I'm just trying to clarify which was done by which party. But did not hold an independent investigation. And without that independent investigation, the court wouldn't have an understanding of the import of the terms based on the instruction from this appellate court on October 23rd of 2019. And then I will complete my argument in rebuttal. Thank you.
Thank you. And Mr. Reed, I understand that you're just going to be arguing. Whoops. Can you hear me, Mr. Reed? Now we can't hear you. You need, oh, there you go. All right. Now, can you hear me?
I can hear you. Yes, much better.
Okay, excellent. So you have 15 minutes.
Thank you, Your Honor. Your Honor, for the record, my name is Orville Reed, and I, along with David Hilkert, represent one of the appellees, Lisa Madden. By agreement with co-counsel, Mr. Meeker, I'm going to be using up all of the time today, as is necessary to explain our position on this appeal.
Thank you.
First of all, Your Honor, Your Honors, thank you and good morning, counsel. First of all, Your Honors, I believe that we're all in agreement on one thing, and that is the decision in 29032, Court of Appeals case number 29032, which was decided October 23, 2019, is significant in this appeal. The question is, what are the implications of that decision? In that decision, the court addressed, first of all, whether or not there was an enforceable agreement as between SUMSS and our clients, Lisa and Marsha, and also whether or not the judgment entry was accurate. In terms of whether or not the agreement was an enforceable contract, this court affirmed that decision. And appellant, like a broken field runner avoiding tackles, likes to avoid the issue of whether or not there was an affirmance and what that means. It is critical, really, to this appeal. And it touches upon the importance of the rule of the case and also res judicata. In the underlying case, 29032, this court addressed a variety of issues raised by appellants designed to undercut the enforceability of the agreement, the consent, the voluntariness of it. The court addressed in detail these issues: competency, duress, and authority, and ruled in favor of the appellees. Then it went on to determine whether or not there was a meeting of the minds and whether the statute of frauds was applicable. Again, those issues were determined in favor of the appellees. The court then addressed the issue of whether the mention of non-parties in the judgment entry and whether or not the probate court was an issue in the case. And the court again dismissed those as not being valid arguments as to the enforceability of this agreement. On all of the issues that address the critical point, and that is, was this an enforceable agreement? It came down on the side of the appellants, on the side of the appellees, Marsha and Lisa. And that is really critical to this issue because the appellant raises those issues again, and it's totally inconsistent with basic rules of jurisprudence, such as the rule of the case. That was discussed at length in the Nolan versus Nolan case, the Supreme Court decision, and this court has had occasion to weigh in on the significance of the rule of the law, rule of the case. And the significance, of course, is driven by a number of considerations. One, the necessity for finality. Secondly, the importance of consistency. And thirdly, the relationship between the inferior and superior courts as established by the Ohio Constitution. So in this case, appellant argues that the trial court to whom the remand was made should have addressed the issue of voluntariness. And by doing so, by not doing so, their issues were, their case was prejudiced. But in point of fact, this court did not remand the case to have the trial court second guess you on voluntariness. It didn't. This court remanded it to say, look, we are bothered by the fact that there is one term that was included in the judgment entry that was not part of the parties' agreement. And that issue went to the issue of what the court in the judgment entry should have referenced 4 months of rent from January through April of 2018. And the reason the court did that, I think, was because of the fact that in January, the court made a decision, in March, the court made a decision. In March of 2018, the trial court made the decision, this is an enforceable agreement. You should have transferred all of the properties and all of the leases to these people, to Lisa and to Marsha, by January 1, 2018. You didn't do that. That's 4 months later, you also own the rent. And this court said, wait a minute, that may be true, but it's not part, it shouldn't be part of the judgment entry. The judgment entry should consist of all of the terms of the agreement. And the court pointed out in its decision that it's really not up to the court to decide what are the essential terms. It's up to the parties to decide what's essential. And the parties set forth what they considered to be the essential terms in the transcript that was prepared on December 6, 2017. So that's why the case was remanded, for the court, for the trial court, the new trial court, to take a look at what the judgment entry should be in light of your opinion. But you did not ask the court to address the issue of voluntariness, and that court could not have addressed that issue consistent with the dictates of Nolan versus Nolan. It just couldn't have done it. We've also raised the Avantian decision as a reason why this court should promptly dismiss this appeal and should affirm the judgment of the lower court. The Avantian appeal stands for the proposition that res judicata applies in the Court of Appeals just as it applies in the trial court. And you specifically address the issue of a statute of frauds in the first decision. It is set out in a separate paragraph. You take it head on, you rule in favor of the appellees. They do not get another bite of the apple. Again, there has to be some finality to this case. This case it's dragged on from 2014 to 2021, and that's not to say we haven't had ups and downs from the Court of Appeals and some things that had to be done in terms of correcting the judgment entry. But nevertheless, there has to be finality. And that is the function of, or one of the tools that res judicata, one of the remedies that res judicata applies, as well as the doctrine of the rule of the case. And I think those two cases, Nolan and Avantian, are totally dispositive of the issues that have been raised at this point with respect to the enforceability of the contract, which is really the critical issue in this case. and has to be addressed. The other issue is whether or not the judgment entry properly incorporated all of the terms. The only term that I can see that found its way into the judgment entry prepared by our new judge on this case, this is judge number 3 at least, judge number 3, was that it called for the transfer to be made to Lisa, to Marsha, or to LMMS, which is the LLC that was formed to accept the transfer. And if you look at the transcript that was prepared on December 6, 2017, when this agreement was hammered out in front of the court and it was transcribed by our court reporter, it is before the court in many different forms, but everything is set forth therein. And in that transcript, you will find that there was a specific discussion about whether or not we could form a LLC to transfer the properties. Mr. Souls, who was then acting as counsel for SUMSS, and who in fact dictated most of the terms of the agreement, said, we have no problem if you want to have an assignee to take receipt of those properties that we've agreed to transfer to Lisa and Marsha. We have no problem with that. And it's set forth specifically and expressly in the agreement. So for the court to say in its entry, the property should be transferred either to Lisa and Marsha or to LMMS does not go beyond the scope of the parties' agreement. And that is absolutely the only basis I can see for arguing that our present judge overstepped the bounds of the agreement. It does not overstep the bounds of the agreement. All it does is to put some flesh on the bones. The assignee is LMMS, and that's to whom we want the properties transferred. So I would respectfully submit that this court should affirm the judgment of the lower court. I think that the issues raised here barely meet a test of what is reasonable or frivolous. Actually, I think these arguments are unnecessary, they're superfluous, and they are designed to obstruct rather than to further the interests of justice. And I would ask this court to affirm the judgment of the lower court. Thank you very much for your time.
Judge Carr, and I apologize to Attorney Hightower and Attorney Reed, but I'm going to have to run and get my adapter. I'm low on battery.
Okay, that's fine. We'll take a little break here. And when Judge Teodosio returns, Ms. Hightower, you'll have 5 minutes of rebuttal left.
Thank you, Your Honor.
Judge, how is my, are you able to hear me okay?
Yes, we can hear you.
Okay, fine, good.
If we couldn't hear you, we would have told you.
I thought you'd be happy.
All right, my apologies. I'm plugged in.
You okay now? All
Yeah,
right.
I'm plugged in, so.
Okay. All right. Ms. Hightower, you have your 5 minutes remaining.
Thank you, Your Honor. Your Honors, a few things to respond to. First, I wanted to respond to this LMMS, the purported assignee. The problem that we have with LMMS being added to the February 26th order is that there was no hearing, there was no due process, there was no opportunity to be heard, there was nothing that was filed with the court demonstrating that LMMS was an assignee of any way, whether they were taking over for the plaintiff or not. With this court not conducting any independent investigation, there is no way that this court could have known without a formal assignation document whether or not LMMS was in fact the assignee of the plaintiffs. When we look at specifically the second page of that judgment entry, it indicates to be transferred to LMMS. It does not say LMMS or the plaintiffs. That was fully briefed in our brief as one of the reasons why this is problematic. In addition, and there's a case, and I'm remiss because I did not supplement it to the court. It was filed on May 5th of 2021 called Lundeen versus Turner.
And you do need to do a special motion to supplement for additional authority, because it's not fair to the other side to argue things that they haven't had a chance to respond to.
Okay, well then, Your Honor, I will do so, and I will supplement the additional authority as to the Supreme Court's position on agreements which contain jurisdiction, which are under one court, but contain jurisdiction that is solely under another court. So I will file a motion to supplement that. In addition,
And
as to,
obviously the other side, the appellees will have a chance to respond then too.
thank
Thank
you,
you,
Your
Your
Honor.
Honor.
Also, as to the statute of frauds, I specifically wanted to address that because I believe that the prior appellate decision indicated that statute of frauds was not raised at the lower court. And so this is why it was raised here. I understand the argument as far as res judicata, but it's not necessary to raise statute of frauds at the lower court when you are presiding, when you are presenting information to a judge. You only need to raise it at the lower court if you're presenting it to a magistrate, or if there is a forum where you are required to first file something before going to the appellate court. And so we believe that statute of frauds was never actually considered by this Court of Appeals as whether or not this needed to be in writing, because there was never.
But we nonetheless said that it was waived. So wouldn't that be an issue of error that you should have tried to take to the Supreme Court? Or
I
a motion for
understand.
reconsideration at the very least?
I understand, Your Honor, and with all due respect intended, typically this appellate court will usually, if there is a reversal of the final and appealable order, once that comes back, then all of the issues that would have been raised, on appeal would be ripe for consideration. I think this one, for some reason, was slightly different, where we're trying to part and parcel present information to this court where there were some rulings which were made, but the final order was reversed. And so had it just been a reversal of the final order, we would have still had everything collectively in one piece to be able to bring to this Court of Appeals. And so I still believe that there's some disjointment as to those issues that do not, or that preclude res judicata. And then finally, as to the issues that were addressed previously with the Court of Appeals, I just want to reiterate that because an appeal was filed, that does not necessarily mean that all issues have to be adjudicated, as it deals with exclusive jurisdiction, and it also deals with additional terms that were added as to directives. This particular court gave directives to the probate court and gave directives to non-parties, which were not included in the purported agreement and were not included in the prior judgment entry. Those are all the addition of additional terms, which was the reason why the original order was reversed. And essentially, in short and in conclusion, I recognize some of the issues that have been brought previously and that are brought now, but we're still attempting to place a square peg in a round hole where it's not going to fit, because there are inherently problematic, unenforceable issues that are occurring here that forces the trial court judge to have to add terms to clarify. And you can't do that without a hearing, because you haven't heard from each side. So that violates due process. Thank you, Your Honors, for the opportunity to present today.
Thank you. Thank you all for your presentations, and Mr. Meeker for attending as well. And the court will take the matter under advisement and will issue a written opinion that will be sent to both sides. As you all know, we also release our cases on the Supreme Court website. So if you're really antsy, you can keep checking there too. All right. Thank you very much. And I hope everyone has a wonderful day.
Thank you.
Thank you. You as well.
We are adjourned until